It is now my great pleasure to introduce today's special guest and commencement speaker, my hero, Sherrilyn Ifill. Sherrilyn Ifill is a civil rights lawyer and a professor of law. From 2013 to 2022, she served as president and director counsel of the NAACP Legal Defense and Education Fund, the nation's premier civil rights organization fighting for racial justice and equality. Professor Ifill is a graduate of Vassar College and earned her JD from New York University School of Law. She is the recipient of numerous honorary doctorates and prestigious medals in higher education in the legal profession. Professor Ifill began her legal career as a fellow at the American Civil Liberties Union before joining the staff of the Legal Defense Fund as an assistant counsel, where she litigated voting rights cases throughout the South. In 1993, Professor Ifill left LDF to join the faculty at the University of Maryland School of Law in Baltimore. We have at least one alum of the University of Maryland here today. Professor Ifill taught there for 20 years before rejoining LDF in 2013 as its president and director counsel. Professor Ifill's tenure at the helm of NAACP Legal Defense Fund was widely praised for elevating the profile, voice, and influence of the organization, and for expanding and deepening its work across multiple areas of civil rights law. Professor Ifill is currently the Verdon Jordan Distinguished Professor in Civil Rights at Howard Law School, where she founded the 14th Amendment Center for Law and Democracy. Professor Ifill is a scholar whose work has appeared in leading law journals, periodicals, and newspapers. Her book, titled On the Courthouse Lawn, Confronting the Legacy of Lynching in the 21st Century, was highly acclaimed and is credited with laying the foundation for contemporary conversations about lynching and reconciliation. She's currently completing a new book about race and the current crisis in American democracy, titled Is This America? Her analysis has played a prominent role in shaping our national conversation about race and civil rights during a tumultuous period of racial reckoning in our country. Please join me in welcoming our 2026 commencement speaker, Professor Sherrilyn Ifill.
I cannot believe that after, so many years of women being in the academy, we have not come up with a linen robe for women of a certain age. Thank you so much, Dean Chemerinsky. The student leaders, Aaron, yes, all the things. Faculty, staff, parents, friends. I didn't hear an independent shout out for aunties. Yeah, I have 7 sisters, so there has to be an auntie shout out. It's really an honor for me to be with you all today, and I just want to extend my heartfelt congratulations to this class of 2026. Today represents a huge accomplishment. I am painfully aware that these have not been the easiest 3 years to attend law school. Heavens, it's not been the easiest 3 years to be a lawyer, to be a dean, to be a law professor. So let's all breathe in and exhale and recognize what it took to get to this day. I know there have been times when you've asked yourself whether this is the career you should be taking on at this time in our country, whether it made sense at all to spend all of the money and the time and the effort to enter this profession, when the relevance of law and the power of law to do good seems to grow less certain every day. Like every day. As we sit here, I'm sure there's some disastrous legal ruling that has been issued somewhere in some federal court, or some grotesque and embarrassing legal brief has been submitted by the Department of Lawyers that is supposed to represent the highest level of lawyering in our profession. Or there's some judge who has been threatened, or some lawyer, again, from that department who has lied to a judge about the whereabouts of a migrant who has been spirited away to Rwanda or Swaziland or to a torture prison in El Salvador. These are terrible things. We have watched 2 Americans murdered before our eyes in Minneapolis with no charges, no evidence that there will be punishment, that there will be reckoning. We have watched wars conducted with disregard to the rules of war. We have watched targeted killings by our own government with impunity. I feel sure that you have witnessed with shock and dismay the capitulation of some of the finest law firms in our country to the demands of a would-be authoritarian. You've seen them bend the knee, turn over their authority, and offer their professional mastery in the service of a political agenda that clashes with the values those very same firms espoused just 2 years ago. You've watched the very concept of the rule of law, always a dicey one at best in our country, crumble in spectacular form as the highest court in the land announced that one man is insulated from the reach of the law, creating kingly impunity for the leader of our country, who wields control of the most important levers of military, economic, environmental, and law enforcement powers in our country. Never could I have imagined it. But you and I have watched this highest court strip away the right to bodily autonomy for half the population of this country, and just recently consign another 14% of the country, descended from individuals who were held in bondage, descended from those who fought to make this country a democracy, consigned to a political no man's land, barred from federal representation in the name of a concept, colorblindness, that appears nowhere in our Constitution or statutes, and that invites us to live in a fantasy world that defies the truth of our history and our contemporary reality. It's become so distorted that we read a decision 2 weeks ago in which the Supreme Court told us that the 14th Amendment makes it impossible to enforce the 15th Amendment. Bizarro world. To the faculty, I know it's been hard to teach under these circumstances. Decades ago, I was sharing with Professor Zhang that I taught civil procedure and constitutional law, and I'm a huge civil procedure lover, but boy, am I happy I'm not teaching these subjects now. What is standing? I don't know. When does stare decisis apply? I now have no idea. What is the so-called major question? Beats me. Good thing the Supreme Court will tell us what it is when they see it. And frankly, the powers are not separating like they used to. I teach the 14th Amendment, the longest and to my mind most consequential amendment to our Constitution. I teach its history, its power and promise. I teach the process by which this amendment came to be and the process by which it was first stripped of its power in the 19th century. I teach the ongoing attacks that weakened it in the 20th. I teach about how its revival was brought on by the brilliant and strategic work of Black lawyers who had no reason to hope that they could do what they set out to do, which was break the back of Jim Crow. There was absolutely nothing in 1930s America that would make Vice Dean Charles Hamilton Houston and his best student, Thurgood Marshall, just recently graduated from law school, believed that they could defeat a system that was the only system they had ever known for their lives. It was the only system their parents had ever known. And in the case of Marshall, his grandparents had been enslaved. There was no reason for them to hope. And yet they set about creating something from their own imagination. So I teach this 14th Amendment. I teach this amendment that allowed those attorneys to build a strategy and a plan to make the promise of it a reality in their lives. And I teach the way that amendment is being stripped again in the 21st century. I teach the whole amendment, the parts most lawyers never learned in law school, myself included, and I teach the powerful lessons the 14th Amendment teaches us about how we confront this moment in this time of democratic collapse and national fracture. It keeps me strong and resilient, and it keeps me hopeful. I have my days too. When the Louisiana versus Calais decision came down, it was a tough day. I started my career litigating under Section 2 of the voting rights case, filing my first case in 1988, when I was a spanking new lawyer who did not know what I was doing. But I was working with this statute, the Voting Rights Act, and its amendments that had just been upheld by the United States Supreme Court in 1986, and here I was in 1988 going forward to use it. And to read a decision that essentially nullified its power was difficult. I needed to find a way to feel hopeful and resilient. The 14th Amendment does that for me because it represents the possibility of renewal. It is, without exaggeration, the blueprint for the making of a new nation after the Civil War. To approach the 14th Amendment, to study and work with it, is to acknowledge our ability to begin again. As I've said many times, the framers and founders of that amendment were not only the members of Congress in the room who drafted the language, but the founders and framers of the 14th Amendment were all of those who participated in giving meaning to the concepts of freedom, equality, citizenship in the many decades before those legislators sat in that room and put together all of the concepts that became the guarantees of the 14th Amendment. Those founders and framers include enslaved people who insisted on freedom, running away repeatedly despite the most gruesome punishments for doing so. It was so preposterous to slave owners that enslaved people would run away again and again despite the punishment, that they deemed it a psychological condition and called that condition drapetomania. They couldn't believe that people could want to be free that badly. Those founders and framers included abolitionists, writers, poets, participants in the colored conventions, Frederick Douglass, John Brown, Elizabeth Cady Stanton, Frances Ellen Watkins Harper, and of course the legislators whose names we should know like we know Hamilton, Jefferson, and Madison. We should know Thaddeus Stevens and Charles Sumner and John Bingham. And we should ask ourselves why we don't. At the end of the Civil War, they were faced with a country that was broken and fractured. Emissaries had been sent south to assess the condition of the South and found that despite the end of the war, the spirit of insurrection remained. Most whites were prepared to go along with the Union only because they wanted to get their power back, not because they believed in it. They wanted troops out of the South and the levers of political power restored to them again. And those emissaries also learned that the violence and intensity of white supremacy remained unabated. Whites in the South were hard at work, finding ways to hold black people in near bondage through black codes and apprenticeship laws that allowed planters to refuse to free children under the age of 18, but to hold them in so-called apprenticeships, and through violence. And the leader of the country, the man who had heroically held together the Union and won the war, had been assassinated in a conspiracy of Confederates led by John Wilkes Booth that planned to kill the president, the vice president, and the Secretary of State. If you learned in school that John Wilkes Booth killed Lincoln, you should ask yourself why you don't know more about the conspiracy to take down the entire government. What I'm saying is this was a frightening and challenging and unstable time, and out of the remnants, those refounders were charged with creating a new nation, one that would reincorporate the formerly rebellious states, disempower the insurrectionists, integrate into the republic 4 million black people, most of whom were formerly enslaved, as full, emancipated, equal citizens. And the truth of the matter is that they did it. They built the infrastructure for a new America, much of it embodied in the 14th Amendment. In one amendment, they overturned the Dred Scott decision, announcing birthright citizenship, removing caste from the idea of who could be American. They reset the relationship between the federal and state government, prioritized our national citizenship over our state citizenship, abolished the odious 3/5 clause, and included a punishment for southern states that refused to allow black men to vote. They included a provision blocking insurrectionists from serving in public office and gave Congress the power to enforce the guarantees of the amendment. It was an extraordinary accomplishment, and they did it all, despite being thwarted at every turn by the new president, Andrew Johnson, a strong supporter of the Union, but an unrepentant white supremacist who is variously described by his contemporaries as tyrannical, a man of barefaced treachery, and a great malefactor. For 10 years, great progress was made. Klan violence was met swiftly with two statutes, the Enforcement Acts of 1870 and 1871. The Department of Justice was created in 1870. At the same time, to provide a federal infrastructure for the prosecution of Klan violence. There was a near explosion of black schools. Indeed, this period ushered in the creation of publicly funded public schools in the South, something that theretofore had been unknown. Black men voted in southern states, resulting in 16 black men serving in Congress beginning in 1870. Now, you know the story, of course. You know that much of the force and power of the 14th Amendment was undone, most devastatingly by hostile Supreme Court decisions that unleashed Klan violence, that narrowly read the scope of the 14th Amendment's authority, and that gave its constitutional imprimatur to Jim Crow segregation. By the turn of the century, there were no blacks serving in Congress. But that does not change what those men and women did, those post-Civil War refounders. They remade our nation, they changed our constitutional structure, they infused the concept of equality into our national identity. The word equality or equal does not exist in our first Constitution before the 14th Amendment was ratified in 1868. And they left the trail for those civil rights activists and lawyers in the 20th century to pick up and push the country finally towards democracy. There have been other moments of constitution making with other courageous leaders and ordinary people who helped shape this nation. Law professor Melissa Murray at NYU Law School, in her new annotated version of the Constitution, draws our attention to early 20th century amendments to our Constitution, which she calls the People's Amendments, pushed in response to disgust of the people with the Gilded Age excesses, and culminating in the 19th Amendment, which finally and at long last protected the right of women, half the population, to vote. Utterly transformative, right? The amendments that allowed the collection of income tax, the amendment that allowed for the popular election of senators. That all happened in the beginning of the 20th century. What I'm saying to you is that this is the way of our history in this country. It is a work in progress. The ebbs and flows have been dramatic and painful. But it seems always that when we're driven to the brink, it has been the precise moment when courageous founders and framers step up and do the work of recreating our nation. And that will be your charge on the other side of this moment to build a new America. I believe it, and I'm counting on it. It's what keeps me fighting. I know that sitting right in front of me today, and when I teach my classes at Howard, are the founders and framers of a new America. Nothing you do is wasted. You may think that protests that you engaged in that didn't produce the change you wanted was wasted, but it was no more wasted than those individuals who ran to freedom, even when they couldn't make it. It all becomes part of the founding and framing of what America will be. Now, that doesn't mean that those in my generation, Aaron, are off the hook. Parents, I know that these years have not been easy for you either, and parents, let me just talk to you for a second, and grandmas and grandpas and aunties. We have failed in what I regard as a sacred trust. We are leaving our children, we are leaving the next generation with a world that is in worse shape than the one we inherited from our parents. This is a very serious thing. It is a betrayal, to my mind, of our most fundamental obligation. So we don't get to comfort ourselves with the idea that the young people will handle it or save us. There's still work for us to do. But that work must be focused on clearing the way for the next generation to build a new, healthier democracy than the one that served us. The democracy that we lived in has run out of steam. It no longer serves our country. It has fallen victim to too many of our own compromises and to our mistaken belief that progress was inevitable. So we cannot go back. The democracy we grew up with is done. Our job is to stay in the fight, to hold together the infrastructures that the next generation will need to build upon, to protect them and their livelihood against the worst forms of collapse if we can, to listen, to accept, even when we don't agree, the world they wish to build. We will not be the ones who live most of our lives in it. They will. And because they are young, they have the one quality that makes change happen, the quality that those of us who have mortgages and who have most of our years behind us don't have. And that quality is impatience. They want things to happen yesterday, and that's a good thing. The new America they create, and for which we will make space, and for which we will provide support, will be better than the one we've lost, the one that so many of us are lamenting. If we are honest with ourselves, we will admit that that America was deeply flawed. As a civil rights lawyer, I have fought against the injustices bedded in our system of laws. I will not shed tears over the dismantling of the worst parts of it. This includes a justice system in which, as my friend Brian Stevenson says, it is better to be guilty and rich than innocent and poor. A system that results every week in a story about someone who was released from prison after 20, 30, 40 years for a crime they didn't commit. I will not shed tears over the dismantling of a system that produces that result. I have seen the ravages of wealth inequality and environmental injustice and exploitation and gender discrimination and anti-Semitism and transphobia and Islamophobia and all the things. And now as our systems buckle beneath the cruelty and grift of an authoritarian regime, we must figure out what are the things that deserve salvaging and the things that do not. We have the chance to dream again of something better, to fight for the democracy we really want rather than the one we've been conditioned to accept. I want a system of law that does not deny difference, that reckons with our history and the ongoing racism that's part of our national DNA. I want a system of laws that is supple enough to recognize disadvantage and to respond to the realities of disparity. A system that makes space to hear the stories of victims, but also to understand the complex forces of trauma and abuse that make perpetrators out of ordinary people. A legal system that does not throw people away, that recognizes the potential for redemption. A legal system that, even when it holds people in punishment, does so in a way that still acknowledges their humanity. I want a system that recognizes, as the Supreme Court said in Brown, that education is the very foundation of citizenship and provides a free and accessible quality education for our children. An education that teaches young people to read and write and discern and critique and understand. It may be that this is all only possible as our current system unravels. If this new world can be made, lawyers will play a role in making it happen. We won't do it alone. We're joined by artists and teachers, builders, scientists, caregivers, philosophers, an ecosystem of democratic visionaries. But lawyers will be a part of it. And so I'm excited and proud to be a lawyer, especially now, and you should be too. Because the truth is that some of the most courageous and consequential actions taken by those fighting for democracy in this country have been undertaken by lawyers. And in whatever way you choose to practice, as a civil rights lawyer, I hope, an immigration lawyer, yes, if your field is entertainment, real estate, tech, contracts, if you are a prosecutor or a defense attorney, a lawyer for elders or children, an international human rights lawyer, your charge is to find a way in how you conduct yourself in this profession to bring us closer to that world of greater fairness, that legal system that is more just, that creates the conditions for a country refounded yet again, that will inch us closer to our highest ideals. This is not the time to shrink back from fully embracing what we can do in this profession. Think of the superb and courageous work of federal district court judges across the country who, even when scolded and denigrated by justices on the highest court, have relentlessly stood on their post making findings of fact, demanding compliance with court orders, and all while facing relentless attacks on their lives and on their homes from dangerous people bent on intimidating them into abandoning their sacred oath of office. Finally, never forget that underneath all of the consequential, democracy-threatening activities happening in Washington, D.C., separate from the colossal and monumental Supreme Court arguments and decisions, there are still the ordinary, everyday injustices that threaten any claim this country might make to democracy in cities and towns all over this country. And we, lawyers, are still desperately needed to fight those. The person facing eviction or the loss of benefits, the person accused of a crime they didn't commit or overcharged and harshly sentenced for a low-level crime, the person discriminated against in employment and education, the person wrongfully terminated from their job, the family navigating probate while grieving the loss of a loved one, or the individual facing deportation. They need us still and will continue to do so. They will remain the heart and soul of the new America you create. I know you know this, because with all the pressures of this time, some of you worked during your spring break to relieve individuals from warrants and to expunge criminal records. You understand that that is essential work. Hold on to that spirit. So I want to tell you today that you have chosen wisely. You could not have imagined that our profession would demand of us what it demands today, or that our legal system would be facing the crisis with which we are confronted as a country, but here we are. Because you've had good teachers, because you've been surrounded by helpful and supportive staff, because you've had parents and family members and friends who have encouraged you, who have told you to keep going, you are here, ready to step into the maelstrom of this profession with all its challenges and rewards. I want to assure you of the rewards. I have never been unhappy a day in my work as a lawyer. It has been the privilege of my life to do the work I do, and I do it knowing that the generations of lawyers who came before me cleared the path that could allow me, this youngest of 10 children, to live my highest dream of becoming a civil rights lawyer. So celebrate today. Eat good food, drink strong drinks. Embrace your family and friends, dance, read poetry, hold on to your spirit, engage with art and music. Hold on to your humanity. Hold on to your humanity. Enjoy this moment. Then study for the bar, pass the bar. If you don't pass it the first time, take it again. Use your early years to train. Your early years are the time when you should allow yourself to be embarrassed because you don't know what you're doing. Don't avoid those moments when you don't know what you're doing. I frankly hope I never run into anyone who was present at my first trial. I wasn't good at all. But do it early until you get good. There's no substitute for excellence and mastery of your craft. And then step into your role as founders of a new America. Thank you and congratulations to all of you.